What's the trick? I wish I knew. I'm so done with thinking through all the things I could have been, and I know you wanted to. All it takes is that one look you do, and I.
Hello, my name is Firdaus Zulkifli.
My name is Muhammad Azram bin Mayuno.
Hi, my name is Ahmad Aiman bin Wahab.
Assalamualaikum, my name is Muhammad Haziq bin Bahman.
And my name is Zul Azrai bin Zul Hisham, and 5 of us are presenters.
Assalamualaikum, my name is Muhammad Hazarul Zuzairil bin Azhar. I am SN Information Research for this group. Thank you.
Assalamualaikum, my name is Muhammad Tak Termizi bin Yusuf. I am SN Information Research. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Abdul Fattah bin Abdul Kani. My responsibility to this group which is information research. Thank you.
My name is Muhammad Zuhairi. I am a video designer for this team.
Assalamualaikum warahmatullahi wabarakatuh. Our group would like to present about the land. The information, including the National Land Code 1965, transfer, step, traffic security, purchase, agreement, disclose, document, contract for sale, land contract for sale, land contract, memorandum, deed, closing statement, and remedies of charge and discharge. The information is taken from various types of resources, and some of them from an interview with an official at Pejabat Tanah and Galian, and we also take from the internet. Definition of land under Section 5 of National Land Code 1965. That's the surface on the earth and all substance forming that surface. We can see the palm oil. The palm oil is the substance forming. Next, the earth below the surface and all substance therein. The pond we can see is the below the earth. And next, all vegetation and the other natural product, whether of not requiring the practical application of labor to their production, and whether on or below the surface. We can see the paddy plant. The paddy plant are on surface, and the pond is under surface. And next, we can all things attached to the earth or permanently fastened to anything attached to the earth, whether on the below surface. We can see the below surface. We can have the gold and diamond, and above surface we can see the house tree, and next the land covered by water. You can see the pond. Okay, thank you.
So next, I will proceed to the National Land Code of 1965. So the application of the 1965 National Land Code, it is to enforce in all states except Sabah and Sarawak. Besides the NLC, other legislation relating to land law passed at the federal level include: first one is Land Acquisition Act. So under this act, there are also legislation enacted at the state level. For example, the various Malay reservation enactments. So the next one is various subsidiary legislation. For example, the various state land rules. So next is the state authority. So land is vested in the state authority. Under section 40 of NLC, there is and shall be vested solely in the state authority the entire property in A, all state land within the territories of the state. B, all minerals and rock material within or upon any land in the state, the right to which have not been specifically disposed of by the state authority. So who is the state authority? Under section 5 of NLC, the state authority is the ruler or the governor of the state. So next is constitutional issues. So land is a state matter. Only the state legislature may make laws with respect to land. So land comes under the state list under Article 74 FC9 Schedule, exception of the power of the Parliament to make laws under the state list for the purpose of uniformity. So under Article 76 Subsection 4, for example, the National Land Code, it is the case of the East Union Sdn Bhd versus Governor of Johor 1981. So next is the features of the National Land Code 1965. So it is a registered document of title. The register retained at the registry or land office. It is available to the public. It is an issued document of title kept by the registered proprietor. So it is also an evidence of his ownership. And next is conclusiveness of the register document of title. There are two principles. The first one is the mirror principle, and the second one is the curtain principle. It is based on the case of Tehbi versus Marutumatu. So the next one is the mirror principle. So it is the register reflects all the facts and interests of the land, such as the name of proprietor, land descriptions, area of the land, and particulars of the persons that have registered interest on the land. So under section 340 of NLC, the title or interest of any persons or body for the time being registered as proprietor of any land or in whose name any lease, charge or easement is for the time being registered shall subject to the following provisions of this section. So next is the curtain principle. It is a potential land buyer may only need to look at the register to get the information on the land that he is interested in without counter-checking with other documents. So under section 89 of NLC, every registered document of title duly registered under this chapter shall subject to the provisions of this act. So the next one is the register is everything. Under the case of Tehbi versus K. Marutumatu, Creelman versus Hudson Bay Insurance Co. and to enable the investigation to take place as to the right of the person to appear upon the register which holds the certificate, which is the evidence of his title, will be to defeat the very purpose and object of the statute of registration. So the next is indivisibility. So indivisibility of title and interest is guaranteed under section 92 subsection 1 of NLC. The alienation of state land to any person or body under the final title shall confer on that person or body a title to the land which shall be indivisible. Under section 340 of NLC, the title or interest of any person or body for the time being registered as proprietor of any land or in whose name any lease, charge or easement is for the time being registered shall subject to the following provisions of this section, such as be indivisible. However, there are exceptions. The first one is registration. The importance of registration. Under section 206 subsection 1b NLC, no instrument effecting any such dealing shall operate to transfer the title to any alienated land or, as the case may be, to create, transfer or otherwise effect any interest therein until it has been registered. So for example, a purchaser does not acquire the legal title until the transfer to him is registered. So dealings recognized under the NLC must be registered or endorsed. Transfers, charges and leases. So tenancies exempt from registration, statutory liens or caveats under caveat system, and also to protect an unregistered interest. There is 4 types of caveat, which is registered caveat, private caveat, lien holders caveat, and also trust caveat. So So the next one is no adverse possession. No adverse possession against the state nor against the registered proprietor of any land. So the title to state land can only be acquired by the process of alienation and no other. So under section 48 of NLC, no title to state land shall be acquired by possession, unlawful occupation, or occupation by under any license for any period whatsoever. So under section 341 of NLC, adverse possession of land for any length of time whatsoever shall not constitute a bar to the bringing of any action for the recovery thereof by the proprietor. So this is under the case of Siddiq and Oz versus the state of Perak 1982. So the next one is reversion to the state. It is alienated land will revert to the state under several circumstances. Under section 46 subsection 1 of NLC A, upon the expiry of the term, if any specified in the document of the title thereto. B, upon the application in document of the upon the publication the gazette of a notice under section 130, that is to say a notice published on the making of an order of the forfeiture by the land administrator on the ground of non-payment or rent or breach of condition. C, in the circumstances mentioned in section 351 and 352, which relate respectively to the death of a proprietor without successors and the abandonment of title by the proprietors. And D, upon the surrender thereof in accordance with the provisions of Part 12. So next is equity. Failure to register or non-compliance with the requirements of NLC, for example, unregistered charge, failure to enter a lien holder's caveat. NLC is not concerned with dealing which do not comply with its requirement, no remedies under NLC. So next is will equity apply. So under section 6 Civil Law Act 1956 excludes the applications in Malaysia of English land tenure, including English equitable principles relating to land tenure. Example, mortgages, equity of redemption. Under section 6 of CLA, nothing in this part shall be taken to introduce into Malaysia or any of the states comprised therein any part of the law of England relating to the tenure of or conveyance or assurance of or successions to any immovable property or any state, right or interest therein. So this is under the case of Haji Abdul Rahman versus Muhammad Hassan 1917. So, however, there is nothing in NLC that prohibits the application of general equitable principle. Thereof, general equitable principles applied by virtue of Section 3 CIA to the extent that they are not inconsistent with NLC. So, another provision is Section 206 subsection 3 of NLC, where it states that provisions of the NLC which require that dealings be registered shall not affect the contractual operation of any transaction relating to alienated land or any interest therein. This is under the case of Mahadevan versus Manilal and Sons 1984.
Right, there's 4 steps in taking the securities. The first foremost is the valuation of the property. Is it the property freehold or freehold? Is it for commercial, residential, or agriculture, or is it the Malay reserve? Moreover, where is the property are located? As accurate evaluation may prove exceedingly difficult, the banker will insist a professional valuer to evaluate the property. Right, that's the first one. The second one is about the investigation of title. It also needs a document of title. the function of document of title to ensure that the customer has a good title of the property in question. The bank should examine the document of the title of the land office of the registrar document of title. The presentation book is so important to indicate with the dealing and any awaiting registration. The caveated presentation book will indicate the caveat awaiting entry. Dealing and caveat are registered or entered in the order in which they are present. The third one is about the creation of charge. Land, whether freehold or freehold, may be charged for any repayment debt. A legal charge of land affects the registration of appropriate and register. An equitable charge, on the other hand, is an unregistered one, where the banker accepts the equitable charge as security for advance. She should request the customer executed. The banker's standard form of memorandum deposit has been deposited and the intention to changing land or to the bank. The last one is about the education registration of charge. It is an instrument of charge will be prepared of regulation by each of the parties involved in the sum within the month of education. When the instrument is presented to registration, a short description will be recorded on the presentation board. Charged by a company, it is must additional to be lodged with the registrar companies within 30 days of its execution to enable it to be enforceable. The banker must be ensured that the company has the capacity power to create a charge of a charge, the charge and the charge is executed in accordance with the memorandum and article of association. That's all.
Next is transfer. According to section 214 National Land Code, the following are capable of being transferred under the code, namely the whole, but not part only of any alternate land, the whole, but not part only of any undivided share in any alienated land, any lease of alienated, any charge, and any tenancy exempt from registrations. Next is purchase agreement. One of the first things you will need is a purchase agreement. A purchase agreement is a legal document that the buyer signs when making an offer on the property. This simply indicates that the buyer intends on going through with the purchase provided all terms of the contract are met. If you plan on offering seller financings, you will need to indicate that the buyer's offers is for a land contract. In this case, you will need to include the purchase price, length of the payment term, down payment, and any other terms of the land sale in the agreement. Next is disclosure document. You may be required to disclose certain defects of the property. Real estate disclosure will vary by state, so you may consider working with a real estate attorney to ensure that you have made all of the proper disclosures. The seller will want a copy of this document along with the signed form. Okay, for contract for sale, if the buyer has secured financing or is planning on paying with cash, a contract for sale will be necessary. This contract will specify the terms of the sale and may also specify other documents required before transferring the deed. This may include the financial documents that are necessary to secure financing. The contract may also indicate that title insurance will be provided. In this case, the title company may be involved in the transaction.
Next, land contract. If you be offering financing, you will need to create a land contract. This is a separate legal agreement or contract that lists all of the terms and conditions that you and the buyer agree on. In the very last, your land contract should include the address of the property and a full legal description of the land. It should also include the down payment amount, purchase price, the number of payment that will be made, the monthly payment amount, and any balloon payment that may be required. You may also consider creating attaching amortization schedule. Additionally, the land contract should indicate how many payments will be made, their due date, grace period, if applicable, this fee for late payment, and how the buyer should deliver each payment. Under a land contract, buyers are usually treated just like a property owner and will be responsible for paying property taxes, insurance, and any utility bill associated with the land use. Next is memorandum of land contract. If you have created a land contract, you will also need a memorandum of land contract. This is essentially an abbreviated legal document that refers the main contract created. This simply serves as a public notice that the buyer is interested in the property without you and the buyer having to disclose and record the entire land contract. Because the deed of the property will not be filed until you have received full payment on the purchase price indicated in the contract, this memorandum will be filed with the county and the city to serve as a record that the buyer is interested in the property. Keeping a description of a property and its address should be listed on the memorandum, as well as the name of both of you and the buyer and the date of the land contract. You will need to sign the document and have it notarized. Next is deed. A deed should be required in order to transfer the legal title of the property to the buyer. If the buyer already have financing or is paying in cash, you will want to have the draft deed with you at closing. The deed will need to be transferred to the buyer and filled and filed with the appropriate government agency. If you are providing seller financing, you will still need to draft a deed, but this deed will be held in escrow until the final payment is made. Once the payment is made, the deed will be filed with a respective government agency, typically the county clerk. You can have an attorney, title agency, or a financial institution hold the median in escrow for you until the buyer makes the final payment. Next is closing statement. For customer, if you are financing the deal, a closing statement will also be required that detail the credit and debit to each the seller and the buyer. A title agency or an attorney can prepare the statement for you, and it may include an amortization schedule that show project payment to be made by the buyer. Thank you.
The next is the remedies of charge. The first one, sue the customer or repayment. Banker normally take a written agreement from the customer setting out the condition of the charge and including a covenant of a part to the customer to be personally liable on the debt. Banker can thus sue the customer on his personal convention to pay. The second one is about the enter the possession. Taking possession of a property and may be exercised by the first stage only is also rarely expected. Enter the possession, there's two types. The first one, where the land is corrupt, where the land is occupied, the bank will receive the rent. But if the land is not occupied, the bank will go into occupation and charge, may grant losses and collect the profit. Also, appoint a receiver to manage the property and collect rent. Also, order of property, state authority, insurance exposures, repairs, payment, and all the sum due to charge under charge. Capital value of land is also not expired. The third one is about the sell the property. It also make the sale of land charge. The charge may serve a notice on the recurring of charger to remedy the breach within requirement time. and also then apply for an order of for sale of the land. Order of property, the state authority insurance expenses incur sales rent, the amount due to the characteristic charge of the time of the sale. That's all.
As conclusion, land can be used as a perfect collateral and easy to manage if all the progress is according to the proper law and procedure. The National Land Code 1965 has many information regarding the possession of land in Malaysia, and some of these they use in nationwide. We hope that the video will help us to increase our knowledge about land and how to use as collateral.